All right. Another episode of the Justice College. Already we've grown 50%. We've got Cal Sherman here,
We gotta keep this
right?
growth up, man. This is
It's
great.
it's amazing. Compounding interest in trial lawyer will make us all wealthy. Uh, we got Tall Chuck here, Charles Bennett, coming to us from Dallas, Texas. Our new participant, Cal Sherman. Why don't you tell us where you're coming from and what you're about?
Coming from Lafayette, Louisiana. I've known Chuck for a long time and taught with him at trial structure and before that some other areas, and excited to be here.
And I'm Philip Miller, sometimes known as the Rogue Lawyer. I am the moderator because I'm the least skilled trial lawyer of the people in Justice College, but I like to bring the interesting bits to the party. I'm currently sitting in controversial Trump International Golf Course in Doonbeg, Ireland. Wonderful spot. Not a lot of Democrats here, but not a lot of trial lawyers here. But
There's
I'm
exactly
enjoying
one.
I'm enjoying golf, enjoying Ireland. All right, gentlemen. What's going on this week in your guys' lives?
Well, we I'm a little frustrated. I have gotten ready for a big trial. It's supposed to start August 12th in Illinois, and we got there, and right before we started, the defense asked for a continuance, begged for continuance, and got the continuance, and now we're not going until January. But what I've learned through this process is I think I've come up with a new way I'm going to start trying cases. And what we have done is we're doing a lot of trial depositions, and it it works perfectly with the type of structure I use, because in our trial structure we talk about, we showed the defense all this stuff and they're still making us go to trial. Well, we've got all these trial depositions, and so we know what their defense is. We know what's coming to trial, so now we can tell the jury, hey, they had all this information, and here we are. We're still here, and I think it's going to be a match made in heaven. This kind of speed trial concept with the trial structure format that we use. So I can't wait to try this case in January. I'm a little bummed it's put off a few months, but it gives me a chance to fine tune it and really really try this out. I'm
And
excited.
Kyle, one of the things that we do that you and I have talked for a long time is having a structure and an outline and being hyper prepared for not just a trial but any trial. And I think what you're talking about with the canning depositions, having them up on videos, and then having the case ready to go uh, can help us with one of the most frustrating things about our practice, which is that it's a lot of hurry up and wait.
Yeah.
We get set up on a trial date. We're on the court's calendar. Sometimes we're even number one, and then we get to court and something happens, and we get bumped another 6 months, and we've got to go back to our normal job and then wait 6 months to go back to trial. So, tell us a little bit about how that. I know you're frustrated right now with this trial being continued, but how does your style, not just with the videotaping depositions, but overall, help you prepare for trials in a quicker way?
Well, with the trial structure, I always kind of we have it in this box format, and I always compare it to if you're putting together a entertainment center. If you put together an entertainment center and you screw all the screws real tight as you're going, it's going to be a nightmare. What you do is you keep it loose, and then you put it all together, and then you the screw them tight to finalize it. Well, that's the way I do my trials. Basically, is every case I'm using the same formula, and all the trials, they always have the same three things. It wasn't our fault; it was somebody else's fault, and it wasn't that big a deal. So we find that the trials are all the same. So I have this format, and then at the end, I just make the fine tune changes, and it's not like I'm reinventing the wheel every time. And I think with this new way, I'm gonna start trying my cases. It's gonna work out perfectly. Uh, like I said, I'm frustrated. I got to wait till January, but basically, I'm pretty much done. I'm going to call two or three witnesses live, and we've got everything else in the can. Discovery's closed, so I don't think it can hurt me. I know what their experts are going to say, and used to be a big proponent of bringing people live, got to bring them live. I don't know anymore. People are so used to seeing things on video. We're so used to looking at small screens. We're so used to getting our information not live that I think this is the trend, and I'm excited to try it out. And
You know what I love?
and when it does go wrong, I don't have to pay 3 expert fees and worry about getting a refund back because it's already in the can.
So this is perfect. So we endeavor as a group at the Justice College to help trial lawyers get better. And that analogy you just gave of making an entertainment center, I think is gold. Because we've all put them together. And if you overscrew at every step, you cannot make any adjustments. But the way I haven't heard you say that before, but the way you said it, I think a lot of lawyers kind of overscrew every step of their practice so that they're inflexible. And anything that happens causes them stress, or, you know what I mean? Like they have a breakdown. And it's interesting that you, with a background in Brazilian Jiu-Jitsu and working with horses, have like a deeper understanding of what it takes to be successful. And nobody is telling trial lawyers that it's not about rigidity, being perfect at every step. It's about that calmness to adjust. It's a beautiful. So if anybody's listening and has questions, just pop them into the channel and we'll answer them. We promise. But how do you guys see the difference between rigid versus flexible strategies when it comes to these unexpected circumstances?
Personally, I look at a trial as a living organism. If you go in with a set plan, something's going to change. I mean, if you're not, Jerry Spence told, when I first started studying Jerry Spence, the first time I ever met him, he talked about the most important skill a trial lawyer can have is listening. It's not speaking, it's listening. And you've got to be listening to know what's going on. You'll start off with one villain. You think that person's a villain, and mid-trial you find out that it's not. And if you're not paying attention, and if you're not able to adjust on the fly, then you're dead in the water. You got the wrong villain, you're going to lose. And with the trial structure that we use, it's perfect in that I'm basically trying the same case every time. And just like you were talking about jiu-jitsu, in jiu-jitsu, it's about drilling. That's how you get better. You get better doing the same thing over and over and over and over. Well, if I'm trying my cases the same way, then I'm doing the same things over and over and over, and I'm getting better and I'm better and better, and I'm figuring out what works and what doesn't work. So I'm not reinventing the wheel every time I start a new trial. I'm just basically taking out something and putting something else in, changing a name here or there. It's amazing how much of the same stuff you can use trial after trial after trial after trial. But the difference is it gets better and better and better and better. It's kind of like if you build houses. Your 100th house that you built is going to be better than the third house you build. But if you're using the same structure and you're just improving on it, it's even going to be that much better of a house than if you're trying new houses every time you build a house. Does that make sense?
Yeah, like for me in the military, we have SOPs, which are, kind of the cumulative experience of people who have come before us. So we do things the same way in preparation, but then we say no plan survives first contact with the enemy. And so, I know, Chuck, you're a big proponent of planning. I think too many people think that planning needs to be cemented and executed exactly as to the plan. How do you relate that to trial lawyers when you're teaching them?
Well, let me use an example from this week. Is I had a hearing earlier this week, or the end of last week, and I had planned out and outlined my entire argument, and I'd practiced it and I'd worked on it. Not for a long time, but maybe for 30 minutes or so, maybe 45 minutes before the hearing. And I was ready for, if the judge asked me to go, I knew exactly what I was going to say. And the judge pops up, it was on Zoom, and she comes in and she goes, okay, I've read the briefing and I'm going to grant Mr. Bennett's motion. So I never got to use what I had prepared to do, but we won the hearing. And afterwards I was bummed because, I thought it was good and I thought it was going to help win the hearing, which I did anyways. But then I started thinking, this has helped me to frame the case. It's helped me understand the case better. Every time that I think about the case and I talk about the case, it gets more clear in my mind. It's more clear for the people around me. And so I think, like the great philosopher said, Everybody's got a plan until they get punched in the mouth. That was Mike Tyson, the great philosopher. And I mean, he's right. It's like you have to have a plan going into the ring, whether it's jujitsu or boxing or going into the battlefield like Philip or going onto the court like with me. You have to have a plan because you need to visualize all of the different options that may happen when you're out there. But that doesn't mean you're going to follow the plan exactly. But you are going to do much better because you have the plan. And that's what Justice College is all about, is giving people a way to plan and think about cases from the very beginning, throughout litigation, in discovery, depositions, and all the way through trial, but then being able to pivot because you have the experience and you have thought through the different objectives or different scenarios that may pop up.
It's easier to adjust too if you have that system, because you're going to be falling back on the system. You're not going to be falling back on something that you never tried before. You're going to be falling back on something that you've done over and over and over, and you're just making minor adjustments. It's kind of like in, when we do voir dire, I don't go up and just wing it. No, I have a plan, and I even have scripts that I have memorized. Now, I don't get up there and say them like a script, but I have to digest them so much and said them so much that they're now my own. And it's so easy to be able to jump to something I used before because it's something that is already in my tool bag. And that's what's great about having a system of everything you do. A system for how I prep witnesses. I have a system for my voir dire. I have a system for how I structure my cases. My openings and closings are very similar. So, and you know what the biggest thing is? What is a lawyer's kryptonite? My ex-wife, I'm much healthier than her. I eat better than her. I exercise and all this stuff. And she had told me one day, she said, I'm going to outlive you. And I was like, yeah, right. And she said, stress. I was like, shoot, you got me. Stress. And when you have this system, it takes away big majority of that stress because it's, you know what you're doing, you got your plan, and it's not the fear of the unknown.
The thing that I find is interesting is like the young lawyers or even the middle-aged lawyers who are kind of struggling. I don't think they have the systems. And one of the things that I think we're doing at Justice College and building this trial procedure, it's kind of similar to battle procedure. Every U.S. officer and sergeant learns the 13 steps of battle procedure. And it forces you to go through, and we're always focusing in these trial lawyer conferences on kind of just the voir dire and the trial stuff, but not about the procedure to build up. And so one of those steps is do a ground analysis, like a map analysis, a weather analysis. And so in the end, let's say I'm a platoon commander and I select a left flanking. And then I move into the operation, but I see I can't do it. Well, because I've done the whole procedure, I've done the analysis, I know what the ground looks around me so I can pivot. So that's where your guys' preparation steps are. You do your preparation, you have your procedure, but you've looked at every option. So if you have to make it audible, you already know the evidentiary issues if you have to go down that road or if you have to go, you know what I mean? Like, so you're just not cemented to one thing. Like, do you experience that? Have you experienced that in trials ever?
Let me take that one, Kyle. So here's an example of from my basketball that's similar. Is when I was in college, we didn't have an offense. We had what's called a motion offense. So we never ran any plays. It was just whatever happened. And we did that because the coach thought that would help us to be more free and whatever. When I got to Europe and started playing professionally, we were very regimented in the plays. Like every time down the court, we would call a different play and we would do something different. And it was much easier to be imaginative within the system in Europe when we had plays every time down because we knew where everybody was going to be, we knew where the defense was going to be, and we could play off of each other much easier. In college, it was just like chaos and nobody knew where to go, and so we couldn't be as free to play off of one another. So the system in Europe actually helped us to be more free and imaginative, and I think the same thing happens not just with trial with the system that we have with Justice College, but also in litigation when we're doing motions, when we're doing depositions, when we're doing discovery and all of that is because I know what story I'm building, because it's always the same story. then I can be more creative within that system and within that story to get what I need to get on that particular case.
Basically, the way we try cases using this format is it's the system. So imagine having to come up with a demand letter every time. Meaning every time you had to come up with an original demand letter that was nothing like any other demand letter you had done before. Can you imagine how much more work you would have to do? Well, it's the same with trial. You know, when I start a trial, I already have my opening format. I just got to plug in the facts. I already know what I need to get by the time I go to the depositions because I've done this same case over and over and over and over again. So it's just the system is just it's an undeniable way to practice law if you're going to litigate cases.
So anybody who's out there that's trying to be a top trial lawyer and has their first big case coming up, if they don't have a system in place, that's why it's important to at least have some mentorship or guidance from somebody who, like, rather than have to, like as we did in some ways, have to learn by failure to make our own system. It's amazing to align with somebody who actually has a system, not just like these ego lawyers who say they're amazing, but like an actual system. Like, what's the difference between like your system and what you see some other people who are kind of pretending to have it? Chuck, like, have you seen that out there?
Kyle, you want me or Kyle? I think Kyle, go ahead.
Kyle, yeah.
Okay. Well, the biggest thing I would say the difference is it's actually a system. Meaning, I've studied under a lot of people, and they have concepts, or they promote their personality, or they promote the way they do things. Well, you're your own lawyer up there. I mean, you can bring them in your case, but if you're not going to do that, if you want to learn how to try your own case, you got to come up with your own personality. But having a system that's proven that you know exactly where you need to put everything, it's a major advantage, especially if you're a young lawyer. If you're an old lawyer, it's a fresh way of trying. It's a fresh approach. And let's face it, times are changing, things are changing. Just like what I was talking about with the speed trial. People don't want to be in the courtroom forever, especially when you can get a trial done in 3 days. Because every time a trial goes long, guess who they blame? They blame the plaintiff every time. So having a system and being able to improve on it, and shorten your trial time, I think that's the way of the future.
It's interesting you say that, because having the system, it's like what Winston Churchill said: if I have to give an hour's speech, I need 5 minutes of prep. If I need to give a 5-minute speech, I need an hour of prep. Having a system allows you to be more efficient. But I find with a lot of the lawyers that we work with, they're so terrified that they're going to make a mistake or leave something out. They haven't built up that confidence to not try to get everything in, and so they end up delaying it or making it longer and pissing off everybody. What do you say to those young lawyers who are terrified that everything matters equally, and so delay the process?
That's a great point. We have a saying we call minimum effective dosage. We only want to put in the minimum amount that we need. And we also are very heavy into the concept of 3. People remember things in 3. So when you have a system, it allows you to not over-prepare, to not give too much information, because our system breaks it down into like 3 main categories. And it's an important thing to remember when you're preparing your case, because what you got to understand is the jury's hearing it for the first time. They don't know your case in and out. And if you try to put everything that's happened in the last 3 years in that trial, you're going to lose them in the first 5 minutes. And you're falling right into the defense's hands. That's what they want to do. They want to make it as confusing and convoluted as possible. Whereas the key is keep it simple. Show why they should have paid. This is stupid. This case is simple. It's down to this, this, and this. And that's the way to try cases.
And I think, you keep saying that every case is the same, but you don't try the same case, like the same types of cases. You try, I've tried trucking cases, I've tried car wreck cases, I've tried defamation cases, I've tried contract cases with dentists, sale of dentist practices, I've tried criminal defense cases, I've tried prosecution cases. Like, and they're all the same from a certain point of view of what we need to do. And so once I know the story I'm going to tell, then I can fit my case into that story, and it makes life so much easier. I know the depositions that I take today are much shorter than the long kind of wandering in the dark depositions that I used to take 10 years ago when I first started practicing law, because I had no idea what I was doing. I didn't know what I was looking for. I didn't know what story I was trying to tell, and so I would just keep throwing things at the wall until hopefully I got to something that looks like an element that I need to prove. Now it's like I know exactly what I need from this witness. I know exactly how they fit into my story and into the system that I'm building. I go get it, and then I'm done and I'm out, and I'm confident that I got what I needed.
I think a lot of growth is stunted though because the firms make associates terrified of making a mistake. And so, I've met associates. I was one when I was younger. I'm like, what this case is really about is this. But, at one, I did a deposition and I didn't ask all the questions that the senior partner wanted to be asked. And they're just yelling at me for not doing all of that as opposed to kind of focusing on the main thing. And, for us, you've been in high stakes basketball games. Kyle's been on the court. I've been overseas in missions. It might be a little easier for us to deal with that stress, to make that call earlier. But what do you say to this lawyer who performed in school, went to law school, and is a trial lawyer, but hasn't really been in a cauldron of performance in another environment? How do we help these lawyers feel more comfortable making the hard call?
Preparation. I mean, that's the key, especially when you're inexperienced. You just got to prepare. And when I mean prepare, it's you're practicing your skills, you're practicing your voir dire scripts. You're getting it down to concise, tight stuff instead of getting up there and trying to wing it. In your depositions, you figure out exactly which important things you need, and you go get those things first. And depositions are fine. I mean, I've had people, co-counsel, ask too many questions and screw up everything I had done. But that's usually not the case. It's but one of the things about, I keep going back to it, but one of the things about having that system is you're not going to have to worry about giving too much information. And you're not going to have to worry about missing something because you already know what you have to get, and it's there. And the way you do the opening, it's the same basic opening every time. You're just changing some facts, but it's the same structure, so you're not going to miss anything.
But it's like what I want to help people understand is it's almost balancing insecurity versus ineffectiveness, because you have to miss a certain amount of critical 3-pointers, or you have to have made mistakes and what I find in the lawyers who are struggling to get better is they don't have that honest mentorship that encourages them to make mistakes so that they can get to this point where it seems easy for us to talk about standing up to a judge, pivoting based on a new piece of information and going a different direction. I think our backgrounds helped us do this, but how do those lawyers sitting in a rural town with their first trial or being in a big firm with a tyrant boss, what advice do you give them so that they can get over that insecurity of making an error? Yeah, seriously.
That's the biggest problem I see with our industry. I have to work on weekends. I have to work early in the morning or late at night to get things done because I get so inundated with freaking everything about SEOs and trying to get clicks. And it's almost like practicing law is about the smallest part of my job anymore. People aren't litigating like they used to. People aren't preparing to litigate like they used to. It's changed. It's changed. It's not about who's the best lawyer. It's about who can get the cases. And so if you do have a system and you are prepared when it is time to try those cases, that's where because there's not a lot of trial lawyers out there anymore.
I got a good idea. Tell me if you guys think this. And we haven't talked about this at any of our conferences or anything, but I find the law is actually bad at mentoring because it's very much, you're going to be a second chair, you're going to carry my bags, you're going to do everything. But I think the best learning happens when somebody senior is beside you in case of emergency. And so imagine you're a young person who's got a great case, rather than give it to a big person to run, why not bring on an experienced person to sit beside you? And then you can kind of run the case, you can have some arrangement. But then if you run into something you haven't expected before, they're there as insurance. I think that's the best way to learn, as opposed to you just sit there beside some hotshot and you're kind of taking notes, trying not to miss anything. You can't really learn. But if you're actually doing it and you had a Charles or a Kyle beside you while you run this case, that would be the way to get your legs. What do you think about that?
I mean, that's what I had when I started. Is at my firm, I had some older lawyers that actually, or more experienced lawyers that actually took the time to help me prepare and then let me do a lot of the trial. And it was small car wrecks, and it wasn't a big money deal, but it was a big deal for me because of that pressure to be first chair with a more experienced lawyer sitting second chair. And I think that kind of helped me realize the path that I wanted to take, which was to not, I didn't want to settle for just being a marketing lawyer. I didn't want to just settle for how many cases can I bring in and roll over in a month. I wanted something more out of my practice that would last a while, and had lasting power for a career, which was learning how to try cases, learning how to litigate cases, learning how to put pressure on the insurance company and maximize the value of the cases for my clients, as opposed to just, well, how many cases can I roll through this month or this quarter or this year, which to me doesn't take any skill besides just pushing paper and being organized.
I would say, and the suggestion I would make towards a young lawyer is this. I would, because it's easy to get caught up in the day-to-day grind, and it's easy to take the money when it's, when you're not going to be, it's a fair offer, your client's ready to settle. I mean, it's so easy to take the offer. But what I would do, if you really want to cross that bridge into becoming a competent trial lawyer, where you're not stressed out, or unduly stressed out, when you're excited about going to try cases, is pick out some cases where liability is not an issue. Because the last thing you want to do is look at your client and tell them at the end of the day at trial you're not getting anything. But pick a case where liability is not an issue. It's just about damages. And start to some arms. Prepare your client and see if you can get them to go to trial. And I'm not talking about starting off. I'm not talking about something that's going to change somebody's life. But somebody breaks an arm or something and they're wanting to lowball you. Man, prepare that client for trial and twist his arm and go get some trial experience. But again, pick your cases. Pick the cases. Lawyers tend to settle their good cases and stuck trying their bad. How about flipping that and try some good cases? And the other thing is you've got to, you can't wait till the last minute to prepare your client. It's kind of, I always compare it to this. If I went to a bunch of police officers and I said, "Hey guys, we're going to fight the fire department this weekend with the cage fight, and I got you signed up. You ready to go?" They're going to be like, "What the hell are you talking about?" But if I go work with the police officers and I teach them some takedowns, some chokes, and we start grappling a little bit, and then I show them some strikes, and I say, "Hey guys, let's do a cage fight with the fire department." Hell yeah, let's go get those suckers. And you got to do the same thing with your client. The number one fear of people, other than reptiles, because they used to eat us, snakes and reptiles, is public speaking. People are scared to death of that crap. They don't want to go to trial. So you got to start preparing them early. But that's what you got to do. You got to get out there and try some cases. Things will slow down. Who knows? You may start having some fun.
It's interesting what you say when you say things will slow down. Like that's the language of a performer, because when you've practiced and been in the arena, when the temperature goes up, things can slow down. But when you haven't practiced and been in there and the temperature goes up, everything shuts down. Like, it's being in that flow. We all live for those moments where things slow down and we're ready. Chuck, what do you say to lawyers who are so kind of fragile? Like I read that book Anti-Fragile by Taleb, and I think it's really relevant to our profession. We create this appearance of being tough, but they're kind of anti-fragile. If there's a setback, they break down. How do you build resilience so that lawyers can kind of take a setback without falling apart or going to rehab?
I think they have to experience real setbacks. I think in order to understand how losing feels, we have to lose. And to understand how great it is to win, we have to have lost. And I was reading a book recently about the participation trophies that have been an issue in America for the last couple of decades. And I think it's true, is participation trophies are okay for like really, really young children. But once things start to get competitive and the kids know the difference between winning and losing, then we have to reinforce that. And I think that trickles up through adulthood to when people have never really experienced losing, then they don't know how to lose. And if you have to stand up in front of a jury and your client is in a wheelchair and they're going to be in a wheelchair for the rest of their life, and you have $100,000 or $200,000 worth of your own money in the case, and you've got to get up and give an opening statement, that's pressure. And if you haven't lost before at other levels, and then you don't know how to handle that situation. And if you're not prepared, like what Kyle keeps saying about having a system and being ready, then you don't know how to handle that situation. So I think Kyle's advice is exactly the right advice, is take cases to trial, be protective of what cases you're taking. You don't want to set yourself up to fail, but you want to give yourself the best chance to succeed so that you can experience what it's like when you don't succeed, and then you appreciate the work and the practice that it takes to succeed better.
Would much rather my failure be, I thought I was wanting to get 100 grand for my client, and I got 50 instead of, losing a big case when your first case out. But the thing is you don't learn anything when getting your hand raised in the air. You learn when you have to get your ass off the canvas and get back into the fight. That's where you learn. And it sucks that's the case, but that's what has to happen. You have to go take your licks to learn.
So much gold there, and what I find in society, it's kind of black and white. It's like there are some people who are like winning is everything, and there are some people it's like participation trophies, and what they're missing in the context is that winning is the goal, losing is the journey to get to winning. But you don't start winning on day one. You know what I mean? And so you want to, and what your points there are for the trial lawyers that are listening, the cases that are kind of within your skill set now, try them. But don't try cases that are too big because you're greedy and you just think it'll work out because you went to the right college, right? If you have a case that's big, find the mentorship. Get your scars in those kind of early fights, right? Where you can kind of then build them up. But if you're an early person and you're given a championship offer early and you don't get the right coaches with you, you're gonna flame out and maybe ruin your career. That's what I think you guys do so well.
And take advantage of the coach, meaning I've known some attorneys in the past that they had a case that I'll make up numbers. Let's say they had a case that they felt they could get $3 million for, but they bring in some hotshot lawyer who can get $10 million and they make as much money or whatever, and they do better for their clients. So it sounds like a great concept. But the difference is when you do that, go learn. They just end up giving the case to the big shot. He goes, does his thing, and he's the star, and the next case that family gets, they go to the big shot. Whereas if you actually take advantage of it and make yourself, if you're going to do that, make the deal with the guy. Look, I want to learn. This is the two concept. We're going to make some money, but I want to learn. Are you in? Yes. Okay, teach me. And then take advantage of it and do the damn work.
So good. That's where this team, I think the humility element is, we're not helping lawyers to expand our ego. We're helping them because we just know that if we lift each other up, we're all going to be a better community of lawyers. And so when somebody comes to you guys and say, I need help, you don't shove them out of the way when the news comes, right? Like you give them the microphone and like we talk about how this young lawyer had the courage to get out in the community and get this case and work with us. Like that's the difference, I think, from the conference circuit that I see and the way this organization is building people.
Yeah, one thing that I've learned in studying the unconscious mind is people say you can do anything you put your mind to. Well, unfortunately, that's bullshit. However, you 100% can accomplish anything that you can envision yourself doing. If you look at the super talented and the super successful, the difference is belief. That's the difference. There's a lot of super talented people out there, But if you don't believe you can accomplish it, you're not going anywhere. Watch a documentary on Sylvester Stallone or Arnold Schwarzenegger or Conor McGregor. They all have the same thing in common. They believe. So if you want to bring in a superstar lawyer because you don't have the experience and you lucked into a superstar case, well, it might be beneficial just to get that belief because you see he believes in it, then you start believing, then you participate, then you participated and got that that 8-figure verdict, and now you believe you can do it, and that's worth the investment right there.
And let me tell one of my favorite Kyle Sherman stories. When I was first starting this process of teaching trial skills and going around the country and speaking at seminars and all that, Kyle had been doing it for a few years before me, and so I called him up and I said, he answered on the first ring. I had never called him before. I'd only met you a couple of times, Kyle. And I Googled you and called your phone, and like literally the first ring, he was like, "Hey, Chuck, what's going on?" And I said, "Kyle, why do you do this? Why do you take time away from your practice to travel the country, to talk to these lawyers, to try to teach and give back?" And you said, "Chuck, a good friend of mine told me one time that you're the average of the 5 people you spend the most time with." Remember that? And that you decided that the people that you were spending time with when you were traveling around and teaching and speaking at seminars were people that you wanted to be, they were doing things that you wanted to do. And you felt they had skills that you wanted to learn from. And so you surrounded yourself with those people. And I think I had done that just kind of innately before you said that. But once you said that, I really focused on who are the people that are around me? Who am I spending my time with? Are these people positive influences on me? Are they helping raise me up? And what I love about Justice College and what I love about giving back is in doing these things and teaching these lawyers is that I'm surrounded by high-level people that are thinking more globally, that are thinking outside the box and thinking out of the weeds of what a practice of law should be, so that I can continue to grow and be pushed by you guys and the other people I'd like to spend time with.
I just want to tell people, I would add to that saying though, but the conference circuit for the young people who are going there, I think a lot of them are being kind of bait and switched into thinking if they go to these conferences, they're going to get better. And really, it's kind of a market of case hunting. Like, I think it's not just the people who have the most money. It's about the people who have the character that you want to be as well. And in trial law, I think what sets us apart is that we're not big corporate lawyers in Wall Street, who can try to look perfect all the time. We're actually warriors who are in the arena getting bloodied and beat up and fighting these people. And you need to be around the people who have the warrior spirit, not that kind of marketing billboard spirit. Have you gone up against those people, or what are your thoughts on that kind of marketing billboard lawyer that's kind of influencing so many people?
It's tough. You gotta have the cases. You gotta have the cases to have a business. So I'm not saying that those seminars are not important, but it seems to me everybody is just more concentrated on getting the cases rather than learning how to be a great lawyer to do something with those cases. So there's got to be a balance. You got to get the cases, but you're gonna have a happier life if you know what you're doing and you're not faking it. And you're going to do better for your clients if you actually know what you're doing rather than you're just some marketing guru. And if you're doing a trial skills seminar where you're sitting on your ass and listening, then it's probably a marketing seminar.
Fair enough.
It's probably
So true.
somebody wanting to get your case. Go to a damn seminar where you have to get up off your feet and do something. Get out of your comfort zone. That's how you get the bang for your buck.
That's such an amazing point, because being a trial lawyer is about public speaking. And so if you're going to a seminar and you're not practicing public speaking, then it's not a seminar for trial lawyers.
So true, but that's what 95% of what people are paying for right now.
Yeah.
Is to go in and hear stories other people are telling you. Like,
you're going to hear war stories about how great they are and how they hit this big old verdict, and you're not going to come away with anything other than a CLE hour. Get on your feet, get out of your comfort zone. That's the only way to get better. And go try something.
honestly, like talking with you guys is the only time in law that I feel close to what I felt like when I was in some special units in the military. Like, the humility of top performers I see in the guys and girls in this organization, whereas when I go to a lot of the conferences, there's kind of a fake humility, but you can really, for people who are listening to this, like you need to find mentors who actually care. And, the way that Kyle and Charles, you guys talk about it, like people would be foolish not to have you advise. Like you're not going to steal anything from them. But I'm not saying this to promote the organization. I just got a little bit of tingles because I remember what it was like to be around guys who I knew would really want to raise the performance level up, but aren't in it for their own ego. They know they're going to be successful anyhow. They're not there to like pump their own tires. And more people have to get to know you guys.
I train with some very talented jiu-jitsu practitioners. One of my good friends is a 6th-degree black belt. He's one of the best in the world. But guess what? When he's teaching me, he's trying to get better. He's trying to improve his game still. So when you're surrounding yourself, find the people that are actually still training to get better. That's who should be in your circle. It's people who are striving to do better for their clients. And the aftermath of this is better life, being happier, being more fulfilled. But it starts with, I want to get better to do better for my clients. And that's where it should be. That's where it should start.
Spectacular.
I think that's perfect.
Let's give it a wrap here. Let's give it a wrap because I think there's a lot of people struggling who don't feel comfortable saying they're struggling. I think what happens is you perform well in high school, you perform well in undergraduate, you go to law school, you get this job. But I honestly think that a lot of lawyers, trial lawyers, are struggling because they can't actually talk to anybody about what they're going through. What would you guys say, all of us who have been bloodied and have let's all give like a tip to those people who might be struggling and don't know who they can talk to about how they can cope so they can kind of get out of the rut they might be in to feel like they matter.
Get out of the office, go find somebody else that thinks about these issues. Take them to lunch, take them to dinner, go to breakfast with them, whatever. Spend an afternoon with them. Just do something to get out of the grind of answering emails and focusing on your cases and focus on something more globally. Come to a seminar with people that actually care about teaching trial skills where you're not sitting in your chair listening the whole time. And I think that's decide what you want for your career. Do I only want to be known for, hey, I've settled this many cases for this amount of money and I've got this many clients? Or do I want to be known as somebody who, like what Kyle was saying, continues to seek out knowledge and get better, even if whether you're a white belt, what's the lowest, a white belt or a 6th-degree black belt, is you're trying to get better all the time, and it doesn't matter. Those are the types of people I want to be around.
And don't be a faker. Quit being a faker. Saying you're a trial lawyer when you don't try cases. Get out there and become better. And when you tell war stories, tell a bad story too. Tell a good story, tell a bad story. Keep that humility, keep learning. But you're just going to be a much happier person once you've done the work and you're legit.
I think in trial law, they never teach us that it's going to suck. Like you go into a big corporation, you're moving paperwork, you can move up the ladder and get your corner office, but nobody tells you in trial law. And it reminds me of some military courses, the SEALs say, embrace the suck, right? The path to being amazing involves a lot of sucking. Like it sucks. Like embrace the suck, but then, and also I would say get away from the lawyer. To be a great trial lawyer, you have to be a great human. And so go and do something to make you a better human, to give that balance from the office that makes you terrified of judges or, kind of comparison's the enemy of happiness. And you got to be your own person. And, I hope some people reach out to you guys because you guys are really inspiring humans. And I know we want to build this community to lift up those good people who are struggling so that they can get their legs and kick ass and leave their own legacy.
Yeah.
Wonderful.
Right on? All right. Well, we'll see you everybody next week on the Justice College podcast.
Thanks, guys.
Thanks, guys. Thanks, guys. Hoorah.